Well. It seems like there's a buzz in the air, and I can sense that you are all eagerly awaiting the details about the Visa Bulletin January 2024. Also curious about the bill that could potentially wave goodbye to those per country green card limits and also some H1B updates. Stay with us, my friends, because we are about to embark on a journey of information, speculation, and perhaps a few surprises. Let's find out, shall we? Welcome to the Immigration and Jobs Talk Show, guys. I am Rajni Bharara, your new host. Starting today, you'll be seeing a lot more of me on your screens. I'll be right here sharing the stage with some incredible guests and engaging in conversation related to immigration and jobs. But for today, we will be speaking about Visa Bulletin January 2024 and the bills to remove as per country green card limits and H1B updates, like I mentioned before. Also, many professional tips from our renowned guest, immigration attorney Prashanthi Reddy from the law offices of Prashanthi Reddy. So, a very warm welcome, Prashanthi Reddy.
Thank you. Hope you're well.
I'm doing well too. Thank you so much. Thank you for taking our time and coming to the show. And everyone, please note that this session is being streamed live on YouTube, LinkedIn, and Facebook. And the handle is Immigration Talk Show. And also, don't forget to subscribe to us. Well, also, I would like to tell you that if you have a question to the attorney, wherever you are watching, please comment with your questions. We will be glad to answer your question. So, now let's get started with our very first question. Okay, so the first question that we have is firstly with the breaking news. So, the breaking news is on H1B 2024 cap. So, Attorney Prashanthi, my first question to you is what does it mean for our viewers? I mean, if they are not selected, how do they prepare for 2025? If you can please, shed some light on it.
Right. So let me start with the breaking news that the cap has been reached because the last week we were discussing the possibility of a third lottery that has not happened. They have received enough numbers of H1B filings to cover the 65,000 plus 20,000 H1B cap numbers. So they have made that announcement today. USCIS has made the announcement today. So there will be no further lotteries based on the registrations that were done in March earlier this year. So we now have to look forward to next year's lottery that is coming up very soon in March 2024. So people who are interested in filing for that lottery, please prepare yourself. Whether you're an employee or an employer, make sure you have all the documentation and the information required to register. The registration window will most probably be for about 20 days. And if I'm not mistaken, it should be sometime in March. And by April, we will get the result of the picks. There will be a lottery pick after all the registrations are done. Most probably the registrations will be done by the 20th, if it's the same as the last year, March 20th. And they will run the lottery in the next 10 days. And by April 1st, they will announce the lottery results, and then you will be able to file your H1 starting October 1st. You will file immediately, but the start date will be October 1st. You will get 90 days to file your H1. That is between April and June would be the 90-day period to file. And then we wait and see what happens, how many registrations, what the pick rate is, whether it's 30% or it's 10%, more than that. I don't expect a lesser demand for the H1Bs, even though there have been massive layoffs this year. The H1B demand is just so huge that I doubt that the layoffs will affect the actual demand. But let's wait and see. If there is a lesser of a demand, then the pick rate will be higher. So maybe we'll see a 40% pick rate instead of a 30% pick rate. And also, if we are rid of the multiple registrations problem, we are hoping for a smoother process this year, unlike last year where there were multiple registrations to such an extent that there were about 780,000 registrations, as opposed to 400,000 from the previous year. So about double the amount. So waiting to see what will happen. In the meantime, if you require to work in the US, if you require to come before October, then you have to look at alternatives such as the TN, the L1. Perhaps you can work on a B1 in certain limited circumstances. So you could be working on an E2 if you're from Australia. So there are some other options, and O is another option. So contact us if you need further information on cap alternatives.
Okay. So thank you so much for answering the question, Prashanthi Reddy. But now there are a lot of questions coming from the people who are watching us from all over the platform, be it YouTube, Facebook, LinkedIn, as I mentioned, in the introduction. But before I move on to the questions from people or to my next question, I actually would like to ask you one follow-up question. You said something about cap. So I'm sure a lot of people know what cap means, but for the ones who joined us today or who are watching the show first time and who have just joined us for immigration knowledge, so to them, what would you like to tell them what cap exactly is?
So there is a limited number of H1B numbers that can be filed each year. Those numbers, new H1Bs, this is not, we're not talking about transfers of H1 or extensions or amendments. We're talking about new H1s. That is, a person who's never been on a H1 before, they can file their H1 if there is a number, and there are limited numbers available. So there is 65,000 numbers for H1 bachelor's degree holders and 20,000 for US master's degree holders. So a total of 85,000 numbers are released every year for new H1s. But the demand usually every year is so high that much more than 65,000 are filed. And therefore, the reason, instead of like past years where they used to take in all the applications and then reject applications based on a lottery system, which they would do based on actual applications. A few years ago, what they did is they created a registration system whereby you didn't actually have to file the H1s for these numbers, but you just had to register with some information, such as your date of birth, your passport number, beneficiary name, company name, federal ID number. So some fields had to be filled out. It's an online application. Right now it's $10, but that could go up. We don't know. Again, we'll hear more about that later next year, I think. So they've created a registration system, and now based on these registrations, they file they have the actual lottery, and then people file H1. So that's what the H1B cap season is about.
Okay. Thank you so much for answering my follow-up question with so much patience, Attorney Prashanthi. Now, I would like to move to my next question. So, my next question, I think it will be here on screen. If okay, um, okay, so here it is. All right. So, okay, so the question is not mine, but from a guest actually. So, and it is from YouTube. So, someone called Poti Sampath has asked that is it possible to go from a TN visa directly to a green card, or does one have to transition from TN to H1B and then apply for a green card?
It is possible. There is there is something called intent, and intent is applicable to some visas, not all. Now, for an F1 or a B2, there is an issue of intent, meaning you have to show that you do not have the intent to immigrate to the United States. For a TN, there is, and an E2, as I was mentioning, the Australian visa, work visa, there is an intent issue, but it's not as strong as the F1 or the B2 intent. So while there is an intent issue, you can adjust status or file a 485 or file a labor or file an I-140, form a TN to to a perm, and then subsequently adjust status. So you can do that for those limited purposes.
Okay. All right. Poti Sampath, I hope you have got your answer from the attorney herself. And now, what we would like to do is we would like to move to another question. But before moving to another question, I would like to tell my viewers and the audiences who's watching us right now from different platforms that we'll be trying to take each and every question and as much question as possible. But in case we are not able to take your question, please don't get disheartened, because we will try to reply to you and your question. But for now, okay. So the next question that we have is, I'm hoping it to pop on screen. Okay. So it is about how to find H1B jobs for marketing managers, non-technical. And it is, we are finding it very hard this time to find my next job. Okay, so this is not a question from myself. It is actually also a question from a LinkedIn user. So the LinkedIn user is asking us that how to find H1B jobs from for marketing managers, non-technical, and because they are finding it very hard at this time to find their next job. So what would you like to say, Attorney Prashanthi?
I think you got cut off there, and I can't really see the question. Okay, I see it now. Sorry, just had to adjust my screen.
Would you like me
How
to
to
narrate?
find H1B? No issues. How to find H1B jobs for marketing managers? Okay. So a lot of people think that H1s are only for IT professionals. That is not true. Even though 80% of the H1s are used up by IT professionals, software engineers, program analysts, software systems analysts, etc., etc. There are H1s available for other jobs as well, and a good chunk of them are used up by the medical professions. Physical therapists use up H1, doctors do, lawyers do. And in the same way, marketing professionals, it is possible to file a H1 for a marketing professional as well. And the title that we usually use is a market research analyst title. We don't like using the term manager, because when you say manager, it becomes less of a specialty occupation, because a manager position, administrative position, usually requires just a bachelor's in business administration, which is a very generic occupation. So as per the H1B regulations, the degree required should be in a specific field, not a general field such as business administration or arts, bachelor's in arts, or bachelor's in science. But it should be something like business administration with a concentration in marketing for this particular case, or business administration with a concentration or a major in finance, MBA in finance, BBA in finance, so on and so forth. So for a marketing analyst, research analyst type position, or we could call it market manager also, as long as we define the job duties as such, we can definitely do a H1B. In the past, there have been issues with USCIS not approving market research analyst or market manager positions, but they have clarified recently that these type of positions should be looked at on a case-by-case basis and should not be denied just on the basis of the job title. So I've been seeing in the recent past that more and more market research analyst cases are being approved. So I don't think this person should have a problem getting a job in that, filing a H1 in that particular field, as long as he has the related degree. Now the related degree would be a bachelor's or a master's in marketing, or economics, or an MBA or a BBA in marketing. So as long as that's fulfilled, we'll be happy to take his call as well, and see if it's something that we can help him with, or her.
Okay. And what about for the anchor's profile? Because नौकरी की कमी तो यहाँ भी है.
Correct.
All right. So we'll be back right after this message from our sponsors. So guys, you stay tuned, because we have a lot many questions that we need to ask from Attorney Prashanthi.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833 412 8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Thank you so much, everyone, and welcome back once again to Immigration and Jobs Talk Show. I'm your host, Rajni Bharara, and I have with me the very renowned attorney Prashanthi Reddy. So, Prashanthi, since we have many comments, and I will give the first priority to our viewers, and then the topics because we are already here on the media. So let's take the questions from the viewers first, and then probably if we'll be left with some time, then we'll talk about the topics. Okay, so the next question that we have for now
Yeah.
is, so we have a question from Seema Singh, and she has posted her question, I guess, on YouTube, and she wants to know, anyone know how to enroll for H1B stamping pilot program in USA? I heard 20K application will be done, but not sure on what basis they select, and also how to apply for. So, Prashanthi, would you like to?
So they will come up with regulations on this. They've already published it. The most probably the selection will be another lottery. I don't know. They haven't yet told us. We have too many lotteries where the H1B process is concerned. But it could either be a lottery or it could be certain criteria or maybe first come, first serve. We don't know as yet. We are waiting for the instructions that we will get sometime in January. And once we get those instructions, we will pass them on to our viewers as well and to our listeners. So yes, there is a 20K pilot program. They are doing this. The Department of State is doing this on training basis. They want to see how it works before they implement it for everyone. We've had this program in the past, and for those who don't know what it is, basically, if you are on a H1 already and you already have a visa stamped in your passport, you don't have to go outside the country into the consulate to get your visa extended. You can just get it extended here without an interview. You have to submit your passport and photograph and go for biometrics to the Department of State. So all that is done by mail, and then they will send you a notice for biometrics, which you will get done most probably at your closest biometric center, which are already being used for green cards. And then they will send you the passport by mail. And and it'll be stamped. So it's a great process. We used to have this a few years ago, then they discontinued it for security reasons, and now they're realizing how important it is because the consulates are so busy and so backlogged with their visa, with their interview dates, that it's becoming impossible to get an interview date, especially for some visa categories, within the next 6 months. And also depending on which country you're in, but for India, it is terribly backlogged for B2 and for H1 as well. So this is one way of easing out the backlog. And of course, we're hoping that the extension of the the interview waiver extension will happen also, which is set to expire in December this month. We hope that will continue as well, and all these efforts together will help ease the burden on the consulates and get us faster interview dates.
Okay, great. So, Seema, I hope that your question is answered, and thank you so much, Prashanthi, for answering this question. And now I would like to move on to my next question. And the next question that we have is from Zara, and Zara has actually posted a question on YouTube. And Zara wants to know, I want to apply for a green card, and I'm in the UK wanting to work and live in the US. I have a drink drive offense, my only ever criminal offense. Well, we don't know that, Zara. But will that stop me being able to? And if not, what do I do? So, Prashanthi, would you like to answer?
So, Zara, obviously the offense that you've committed, we don't know to what extent what it is. Is it a felony? Is it just a traffic violation? In UK, we don't know what that entails. And since the the crime was not committed in the US, um, it might not have as much repercussions as an offense would have if it was committed in the US. But still, when you're applying for the green card and you fill out your adjustment of status application or whatever it might be, they will ask you if you've ever been arrested and if you have ever, committed a criminal offense. So depending on what the question is, you'll have to answer yes. If it says criminal offense in the US, then obviously you answer no. Have you ever been arrested is a very broad question, so you'll have to answer yes and give all the information pertaining to it. And again, we don't know. It's obviously not a US offense, so it's not a felony or assault or anything in the US. But it might have some repercussions with reference to the issue of moral turpitude, which is, is a topic for a whole segment, where USCIS is looking at what your morals, whether you are a person of lower morals in their view, which is a very archaic term, and there are a lot of elements that come into play when applying for that under that particular section of moral turpitude. So this could be one of them, but again, it really depends on the circumstances to what extent a crime was committed, if somebody was hurt, or it was just, as I said, a driving traffic violation. So it all depends on what the circumstances are. So I think you'd be better off taking a one-on-one consultation and getting a better answer depending on, after giving more facts. But in general, yes, there will be some repercussions, and to the extent of the repercussions, we have to dig deep into it further to know.
Okay. So for that, she will need to take consultation, as you said.
Correct.
Okay, great. Well, okay, so we are, so firstly, before taking, thank you so much, Prashanthi, for answering this question as well. Zara, I hope this answered your question. And now, before moving to my next question, what I would like to say is thank you so much thank you so much, everyone who's watching us right now from different platforms. We are loving your questions here, and we are trying to take each and every question that you have posted on different streams. But because of the time constraint, we'll have to see, how many we can take. And like I have mentioned before also, that in case we are not able to take all of your questions, so what we'll do is we'll try to reply to them on the social media platforms where you have posted the questions. All right. So now the next question here is, okay, so this is quite interesting. We have a question for a holder in the Philippines. Okay. So, and the question is again posted on YouTube by Vishwa Das. And Vishwa wants to know, green card holder overstayed in the Philippines for 5 years, returning to JFK soon. Concerns about entry issues due to overstay and ACS appointment unavailability. Seeking advice.
So if you stayed out of the country for 5 years as a permanent resident, most probably they won't allow you back into the country on a green card. But you could apply to give up your green card, and there is a new process for that. And there is a form also related to that. And you can submit that either at the consulate, but I hear you have to submit that at the port of entry. And so it depends on which port of entry again. So there is a process. Bottom line is there is a process to give up your green card. And then you can enter on a visitor's visa. But entry on a green card is fraught with problems because you'd have to show that you have not given up your residence in the US, and it's rather hard to show that if you've been away for 5 years. You have to show that you are continuing to pay taxes, that you maintain a house here, you're paying rent, you have a job, you have family. There are many factors whereby you can show that you did not give up your residence. And after all that, if you still say that you want to come in, then you most probably have to go before a judge. You'd be allowed in. It depends whether you'll be detained or not. I'm not sure. It depends on the officer. But you might be allowed in with an ankle bracelet or some kind of mechanism where they can track your whereabouts. and they'll allow you to go before a judge, and the judge is usually much more lenient with allowing permanent residents who have overstayed to establish residency here and to show that they still have residency here. But this is, kind of a little bit outside of that limit because it's been 5 years and that's a long time.
Okay. Okay. But what about the re-entry permit?
Well, if you have taken a re-entry permit, you should have taken a re-entry permit before you left. This person doesn't say anything about the re-entry permit that they've taken it. If you have a re-entry permit which you have applied for and it has been approved, that will allow you to stay outside the country for 2 years. Then you have to apply again for a re-entry permit for another 2 years. So if you have a re-entry permit and obviously to get a re-entry permit, you have to, not obviously, but to get a re-entry permit, because a lot of people don't know this, you have to be in the US because you have to get biometrics done, etc. So that cannot be done at the consulate. So if you've done that and you have a re-entry permit, fine, but doesn't look like that's the case in this particular situation.
Okay. All right. All right. Thank you so much, everyone, for sending in your questions, and thank you so much, Attorney Prashanthi, for answering them with so much patience. So now I would like to take another question. So can we have another question, please? Okay, so the question is not from a user, but it is, from the topic itself. So there's been a good news actually for EB1 category based on the January 2024 visa bulletin from the, DOS, which is Department of State. So the question here is, please explain to our viewers, Attorney Prashanthi, in detail on the changes from December 2023 visa bulletin and a good move on the EB1 category.
Right. So that's an important topic that we thought we'll cover today. So I'm glad, the question has been asked. That is, the talk of the hour is both the H1B cap has been reached, which is not good news. But the other buzz for today is that EB1 has moved forward, and EB2 and EB3 also have marginally moved forward. And I was at least not expecting forward movement. But so basically what has happened is there has been forward movement because this is the second half of the year for visa processing. So that's why we see a huge forward movement for EB1 in for both India and China, and also for some other, as I said, employment-based categories, because this is the second quarter of the fiscal year. And so, some additional visa numbers were made available, because visa numbers are usually made available in increments because they want to see how many have been used for the first quarter, and then, they accordingly distribute the visa numbers by quarter. So they've made some other, some additional visa numbers available. As you know, for those of you who know, EB1 has really got backlogged for Indian nationals from being current to going back to 2019. So now in the January visa bulletin, the EB1 for final action dates, again, there are two tables. One is a final action date table, not to confuse you all with too much information. And there is another table which is dates for filing table. So every month USCIS will let us know which table they're using. If it is dates for filing table, that means you can file your green card, but you won't get it until your date becomes current based on the final action date table. But you can file. That's the advantage. And there are many advantages to filing a 485, because you can get EAD, you can change jobs, you can get advance parole to travel. So it makes sense to be able to at least file even if you don't get the green card. So there's been a movement in the final action dates. The final action dates are the final dates based on which you can actually get a green card once you file. For EB1 India, it's moved ahead to September 2021. So there's a jump of 3 years and 8 months for EB1 India. So that's a huge jump. And there are, I know a lot of people in the EB1 category, people who are working in multinational companies, in big companies, they are actually coming directly on EB1 and they're, filing their green cards or coming on an L1 and, accordingly filing their green cards. For China, the date advanced to July 2022, and EB1 is, of course, current for the rest of the world, so there's no change there. There's also some forward movement for EB2, employment-based category. For EB2, the cutoff date moved up to March 2012. That's a forward movement of 2 months. Something is better than nothing because we were not expecting any forward movement because of the, high demand for the Indian EB2 numbers. Similarly, China moved ahead to June 2020, and EB2, all other countries also moved to November 2022. So if you're any other country other than China and India, it's moved up by 3 months and 17 days. Now remember, your country of origin is the country that you were born in, not that not the country that you're a citizen of. So it's nationality based on birth. So you have to always look at the visa numbers based on that. EB3, again, a marginal forward movement of 1 month for India, moved to June for May. So June 2012, not much of a movement. EB3, China has moved to September 2020. And the rest of the world is moved forward by 8 months. So, quite a good forward movement. And of course, we have other categories as well. We have EB5 category, and for India has moved up. If anybody's filing EB5, which is the investor visa, it's moved up to December 2020. So that's a significant forward movement. And similarly for the other categories as well. For EB5 for worldwide is current, so you can file your green card immediately if you don't belong to China or India. Now, as I was telling you, there are two tables, right? Filing action, dates for filing, and final action dates. Now, for the dates for filing table, it looks something like this. There isn't, for EB1, again, there has been a movement. So EB1 has moved to January 2021. That's a jump of 1 year and 6 months. So, you can make use of that and file your green card if, you've reached, if your I-140 was filed, or your labor cert was filed on that date. And in the case of an L1, EB1, it would be I-140 filed on that date. So if you look at the dates for filing and final action dates charts, they're much closer now than they were before. So this forward movement has made the dates for filing and final action date table closer to each other, so more realistic. That's what I've noticed, because it's January 2021 EB1 for India and September 2021 for final action date. So it's about a 6-month difference. But if you look at the amount that it's moved from the last visa bulletin, it's moved by 1 year and 6 months. For India, that's a significant forward movement. For China, it's moved forward by 5 months to July 2023. And for EB1 worldwide, unfortunately, all other countries, there's no forward movement at all. So that's something to keep in mind. EB3, no forward movement for India. It hasn't, it's just stuck where it was. Some forward movement of 10 months for China, and no forward movement for worldwide categories. So it's still at February 2023, which is not bad when you think of India being, 2012. So it's not that bad for the worldwide categories. And then family-based, it's not as exciting, but there's some forward movement for family-based cases. So for F2A, which is basically if you're married to a permanent resident, which is very useful for our Indian nationals, because a lot of permanent residents marry Indian nationals. So for them, anybody who's a US citizen and has married somebody from outside of, somebody from India, basically for them, the dates for India has moved up by 8 months and about 20 days. So there is a good forward movement. The rest, it's just the forward movement is very minimum. F2, F2B, F3, F4, like a few months forward movement. So not much really to talk about for the final action dates. For family-based cases, dates for filing, as I said, there are two tables. There's been no change at all for dates for filing. So effectively, really, no additional people can file for a green card based on dates for filing. So that's in a nutshell what has happened with the visa bulletin. A lot of excitement because there has been forward movement after no forward movement for so many months.
Okay, great. Thank you so much for answering this question, Attorney Prashanthi. But I'm so sorry for having so many follow up questions. And also at a point when we have so many questions, from our viewers actually, and also the topic related questions as well. But before I jump into this next question, which I have on my screen, I just would like to ask you one follow up question. For the ones who have joined us in today's show and who are very new to this topic and who are gaining knowledge about immigration, so if you can please explain to them what is EB1. I mean, I'm sure there are EB1, EB2, EB5, but for now at least if you can please explain what EB1 is.
Yes, so employment based category EB1, EB2, EB3 is the most used. EB1 is there are different categories for EB1. One is multinational executive, meaning you're moving from you're working as a managerial or executive level position. You're working in that position and you work there in your parent company, foreign company, for a year. And that company is moving you to US operations to take care of operations here in a multinational and executive position. So that's one type of EB1. There's also EB1 extraordinary ability. That is for people who have extraordinary ability, as the name suggests, in the field of sciences, arts, sports, business. So it could be anything, any extraordinary ability in these fields. There's also another EB1 category for researchers, people who have extraordinary ability in research. If they are scientists, and you have to show that their research is helping the US in some way. So these are the few, in a nutshell, categories that qualify for EB1.
Okay, great. Thank you so much for your patience, Attorney Prashanthi. Now, next, I would like to move to my another question, and this is about how is how is this good news with the rollover and 161,000 visas, as there is a lot of buzz on media. What is your honest prediction based on your experience as an immigration attorney for over 20 years? So, how many employment based visa numbers were available and used in 2023, and how many in 2024?
Right. So, I think just to go back a step, for those who don't understand even what the question means, and a lot of our viewers, of course, are very in tune to this process and check the visa bulletin every month, and they're sometimes more knowledgeable than we are as to what is going on and how to predict the numbers. I know there are a lot of IT people, crunch the numbers and come up with analysis on what to expect, etc., etc. So, but for those who don't know what all this is about, basically the same way as we have a limited number for H1s, we have a limited number of green card visa numbers issued every year. And out of those numbers issued, every country gets 7% of those numbers. So no matter what the size of the country, whether you have a population of 1 billion people, or you are like Iceland with a population of a few thousand, you still get the same number of green cards for your country, which has resulted in an uneven distribution of green cards because Indian nationals are more Indian nationals because they are applying because there's more population, and there are more IT people who are of Indian origin. So you see that there's an inordinate amount of Indian nationals applying when compared to people from other countries. So the visa numbers are really backlogged for Indian nationals. And we were talking just now about the visa dates, right? 2012, EB2 and EB3. So while other countries are almost current or backlogged just by a year or so. This is because of this phenomenon that I'm talking about. So coming back into your question as to how many green cards numbers are being released this year. So the green card numbers are always the same, but because of a rollover from the unused green card numbers from last year, these green card numbers sometimes vary. So for last year, for example, in 2023, 197,000 green card numbers were made available for employment based. And out of this, pretty much how many were used? USCIS is saying all the numbers were used, so none of them were wasted. And also we have a separate 6,000, no, I believe 10,874 numbers available for EB5, just for EB5 category, in addition to the 197 available for the EB1, EB2, and EB3 and other employment-based categories. So for 2024, which is more relevant, right? Because now we're in 2024 fiscal year already, as of October of this year. The numbers available are lower than last year, 161,000. Again, it's a rollover. It's higher than the basic number because there's a rollover of the unused family numbers from 2023. So that's why it's resulted in 161. But obviously the rollover from the other categories is less than it was last year. As our consulates are opening up and as more family-based petitions are being processed outside the country, you see that there's not much unused family-based numbers as they were during COVID. Because during COVID, all the consulates were closed. So they didn't process any family-based cases or any employment-based cases from abroad. So all the numbers could then be used by USCIS, by the Department of State here. And therefore there were, a large number, lot of numbers available, and a lot of people filed in October of 2020. Indian nationals filed because, their dates became suddenly available. So this year, as I said, 161,000 are available as opposed to 197, and it was 200 and something the year before. So as you see, it's becoming less and less as the family-based cases, the numbers are being used up, at the consulates. And again, we have the same 10,874 numbers available for EB5. So we have to wait and see if the extra visas available, if Congress will allow anything further with reference to this, but there has to be some change in the law or some executive order that will stick. Because if it's something that is, if it's an executive order which is against the law, then there'll be a lawsuit and it won't stick. So we have to see if they come up with innovative ways of increasing the numbers by staying within the law by passing an executive order, or if there is some new law that comes into place which allows us to get a flood of new numbers into the system, and that will allow then the tables to change and the dates to become available.
Okay, great. All right. Thank you so much, Attorney Prashanthi. Now, what I would like to do is I would like to, go to the user's question. But before I go to the user's question and I ask those questions to you, I would like to take a break here because I would want you to wait for a bit, guys, because as you know, इंतजार का फल मीठा होता है. तो इंतजार कीजिए. We'll go for a break and we'll be back shortly.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Well, welcome back again to Immigration and Jobs Talk Show. I'm your host, Rajni Barara, and I have with me a very renowned attorney and your favorite attorney, Prashanthi Reddy. All right, so guys, like I said, that we will be now moving to the user's question. But before I move on to the user's question, I would like to say to you that I hope so far the session is informative and helpful to you. If you need immigration help, don't forget to reach out to Attorney Prashanthi Reddy. You can call her at 212-354-1010, or you could also mail her at prashanthi at reddy at esq.com. Prashanthi will be with THI. So, in case you missed out on writing the contact number or her email ID, what we'll do is we'll mention it in the description box of of a YouTube in a YouTube channel. So you can go there and you can copy the number or her mail ID in case you missed it out. Now, again, coming back to the questions. So now, can we have the user's question here on screen, please? Okay. So the question that we have is from LinkedIn, and it is from Venkat Chalam Athiseshan. Okay, so I would like to call him Venkat. So Venkat wants to know how is the F3 family immigration for India looks like in the upcoming year. So if you would like to
Yeah,
answer,
it's hard
please.
to predict, Venkat. F3, obviously, F3 category is severely backlogged and it has been for a while. So, while I think F2A might move forward, which is permanent resident spouses application, and of course, it helps if you're an immediate relative, so then you don't have any visa number problem because it's exempt from any visa numbers if you're married to an immediate if you're an immediate relative of a U.S. citizen. But for F3 category, I'm not expecting any forward movement in the near future, or not much at least.
Okay. Venkat, I hope you've got your answer. Now I would like to move to another question. And can we have another question on the screen, please? All right. So this question is not from the user, but it is from the topic. So, okay. Okay, so here is the question from the topic, and it is, Prashanti ji, Senators Kramer, Hickenlooper, and Collins introduced in Senate, while in the House, Reps McCormick, Jayapal, Pramila, and Krishnamurthy introduced HR 6542. So our viewers have several questions, in if I talk about in layman's term, if you can please explain what are these bills, and second, what is a bill in the House and the Senate?
So basically, we were just talking about the availability of green card numbers and how we can't expect to see too much forward movement unless there is some new law or new executive order. And this is what it is. There is a bill that's been introduced right now in the House, but I'm not super excited about it because bills like this have been introduced every year but have just fallen through the cracks because they haven't seen the daylight after being introduced because of the amount of partisanship that is there right now in the House and the Senate, and how bills get voted as per party lines. So even though this bill is has been introduced as a bipartisan measure by both Republicans and senators, some Republicans and some senators, in that list of names that you just read out, the voting actually takes place as per party lines, and Republicans are not very conducive to immigration, even legal immigration right now. Um, and especially if it's a Democratic government, then Republicans don't want the Democratic government to um, get the benefit of introducing such a bill. So they will, they're not supporting it for that reason. But the bill is to amend the Immigration and Nationality Act so that they can eliminate completely per country numerical limitations for employment-based immigrants. So as I said, right, there is a limited number of green card numbers available every year, and we have to work within that limited number, and India only gets 7% of it. So India and China are the most affected by these numbers. And in AI and in IT, for these people that and these resources, that it's a shame that it makes sense, because it's a shame that they live in this country for so many years. They are highly technically skilled people. They could be in the medical field, they could be in the technology field, and they're having to leave the country because they're not able to get a permanent foot in this country. So they'll obviously leave to Canada or some other country that's willing to give them a green card and then ultimately citizenship. So eliminate completely employment-based numbers and increase the numbers for family-based immigration. So they're not saying eliminate that also, they're saying increase the numbers for that and eliminate the employment-based. So this was introduced, I believe, on December 1st. And so once it's introduced, it has to, the steps that follow is that it has to pass the House. A majority of the House members have to pass it, and then it has to pass the Senate. And then it's possible that the Senate may have their own version of it. And if they have a different version, then, again, the revised version has to be passed in both the House and the Senate. And then it goes to the president president has the veto power to disagree with it if he wants to. Otherwise, he will sign it, and then it becomes the law. So that's generally the process for that the bill goes through.
Okay. Okay. Thank you so much, Attorney Prashanthi, for answering the question. And also to our viewers who are watching us right now from different platforms, I would like to correct my mistake here. So the mail ID that I set for Attorney Prashanthi is, I would like to correct that. So guys, if you require assistance with your immigration case, kindly contact law offices of Prashanthi Reddy via email at prashanthi@reddyesq.com. Prashanthi with a THI. So you can also see it on our screen. Her email ID is written, and also you can give her a call or a text at 212-354-1010. I would like to repeat the number: 212-354-1010. Or also you can visit the website, which is mentioned here on the screen. And also, if you're looking for a project placement or visa sponsorship, you can reach out to me on my email ID, which is Rajni, Rajni at higheritpeople.com. Yes, Rajni at higheritpeople.com. Or also you could visit our website, which is www.higheritpeople.com. Well, that's it for the information. And now I would like to move to another question. So can we have another question, please? All right. So this question is from a user, and the user's name is Nanda Kumar Venkatesan. And he has posted his question on LinkedIn, and he wants to know that, can you please tell more about EB5 visa requirements, like investment limit and possible to invest as monthly payment method?
No, you cannot invest in a monthly payment method. It's 1 million or 500,000, and there was a proposal either 500,000 or 1 million, depending on where the business is located. If it's in an underserved area, then it's less. If it's in a regular area, then it's more. Underserved area meaning targeted employment area, meaning a place where there is a high unemployment rate. So that's decided by the state, and they have to give a certification that your area comes under a TEA. So the law is, though, in a state of flux, because they want to increase that investment rate. So we have to wait and see what happens. But they have given some concessions with reference to the visa numbers. They have reserved certain number of visa numbers, for certain categories of EB5. And they've allowed the visa numbers to roll over, if not used, from the previous year to this year. So, there's some improvements made with the EB5 process. But going back to the process, you need to hire at least, in addition to the minimum required investment, you also need to hire at least 10 full-time employees in your business, or you can choose to invest through a regional center. So that in that case, it will be a passive investment, and you in both cases, whether it be your own business or it be a passive investment, you have to show that your investment is at risk, which means you cannot have a guarantee that the investment will be given back to you. So if you're investing it in a regional center, you cannot take a guarantee for them that they will give it back to you no matter what, right? So these are a few things to keep in mind, but otherwise EB5 is such a vast topic. It's a topic by itself, so we can maybe discuss that sometime in the future, especially now with the numbers being so backlogged. EB5 might be a good option. But the problem with EB5 right now is the processing time, in addition to the requirements that you have to fulfill, and the fact that the law is in a state of flux. The processing time itself is 3+ years, actually, almost 4 years, just to get the first step approved. And once you get the first step approved, then you get a temporary green card, and then you have to remove conditions on your green card. You have to file for the second step after 2 years. So the entire process is quite lengthy. But some might argue it's still better than EB2 or EB3. So yeah, there's that.
Okay, but for now we do not have a figure, for the investment limit.
It's 500,000 and 1 billion as of now. So, but there is a proposal to change that.
Okay, all right, great. So I hope that answers your question. Now next, the question that we have is from a YouTube user, and her name is Saranya Nirmala. Okay, so Saranya wants to know, I'm currently on my L1B visa. Can I apply for a green card through my employer using my L1B? Or should I go through the H1B lottery, get H1B stamped, and then apply for a green card? What would you like to say?
You don't have to. The law doesn't require you to move to a H1 to file for a green card. So as per the law, you can apply for the PERM. If you're L1B, it's not EB1 category. So you have to choose between EB2 and EB3 category. You'd have to file, again, since you're not an L1A, you have to go through the PERM process and, so file the labor certification and then file the I-140. And then once the visa number becomes available, you'll be able to file the 485. So yeah, you don't have to go through the H1.
Okay. This question is just out of context, Attorney Prashanthi. I just would like to know. So, but why do we have so much problem with the visas? I mean, why is it not, smooth?
Because the immigration system is broken and it needs to be fixed, and there's no political will to do it.
Okay. But why would you say that there is no political will to do it? I mean, have you come
Because
across
they're
such
not willing.
cases where, yeah.
They're not willing to do it. As I said, because they are so busy fighting amongst themselves. So it's very difficult for them to pass any kind of legislature with the present, the way things are. And also because they don't have majority. One Republicans control the House and the Democrats control the Senate. And it's divided. And so if one party doesn't have clear majority, it's difficult to pass any bills, right? Unless there is some consensus, which is not there right now.
Okay. Got it. Thank you so much, Attorney Prashanthi, for the question. Now, again, I would like to take a small break, and we will be coming right away with many more questions. So you guys stay tuned and keep us watching.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back once again. You are watching us on Immigration and Jobs Talk Show. I'm your host, Rajni Bharara, and I am with the very renowned attorney Prashanthi Reddy. So, Attorney Prashanthi, once again, welcome. And now I again would like to tell you that if you require assistance with your immigration case, kindly contact law offices of Prashanthi Reddy via email at prashanthi@reddyesq.com. Prashanthi with a THI. Or you can also contact her on 212 354 1010. 212 354 1010. Or you could also visit our website. And also, guys, if you're looking for a project placement or visa sponsorship, reach out to me on my email, which is Rajni, RAJNI, at higheritpeople.com. Or you could also visit our website, which is www.higheritpeople.com. And just remember that we also sponsor H1B visas and green cards. Now, coming back to the questions. So now can we have another question on screen, please? All right. So next question that we have is from Ashik Ashu. Okay. So Ashik Ashu has posted this question on YouTube, and Ashu wants to know if I am H1B. Okay. If I am H1B, how long will take till I got NYL140 and then transfer to GC? Well, Ashik, I think you need to work on your grammar, but if you can please answer this question, Attorney Prashanthi.
So basically, he's asking that Ashik is saying that he's on a H1B, and how long will it take to get New York I-140? Is that NY stand for New York, or I don't know what it stands for? I'm just going to ignore that and presume it's just I-140 and then transfer to GC. So I am presuming, again, forgive me, Ashik, if I have not understood the question, but I am presuming that you're on a H1 and you already have I-140. That you're asking how long it'll take to apply for the I-140 and then get a green card. So basically, you have to go with the perm process first, and I'm not sure whether you filed that or not, but just, for the interests of viewers, we will answer the entire question. The labor cert nowadays is taking... Sure.
I'm really sorry to interrupt, but I guess what he's saying is if... Okay, so what he's saying is I am on H1B, and how long will it take till I get my I-140 and then transfer to GC?
Not New York. Okay. Makes sense. Till I get my... Oh, good catch there, actually. Get my New York... I'm still reading it as New York. Get my I-140 and then transfer to a GC. We're just so enamored by the question that we can't get to the answer. We're just focusing on the
name itself is very interesting, Ashik Ashu. So the question is also interesting.
So sorry for focusing so much on the question, but so basically you have to file a prevailing wage to start the process, and the prevailing wage itself is taking about 8 months to process. Once the prevailing wage is approved, then you file the labor cert. The labor cert is taking about 8 to 10 months. So you see that it's taking, and this is 8 to 10 months if there's no audit on your labor cert. If there's an audit, it could take up to a year. So right here, you see it's about 2 years or slightly less than 2 years just for the perm to get approved. And then once the perm is approved, you can file your I-140 immediately. And luckily for I-140, we have premium processing. So you could get your I-140 approved in 30 days, presumably, if there is no RFE again. And then you just have to wait for your visa number to become available to file the actual green card or the 485. And this can take several years depending on which category you're in. And if you've been watching the show, you've seen the table that you've heard me and talk about the dates that they're currently working on for the different categories.
Okay. Okay.
So Ashu,
Ashu.
other quick thing is, yeah, your priority date is based on the date that you file your labor cert. So they're working on, for EB2, for example, if it's 2012. So for people who have filed their labor cert in 2012, they're now able to file their green card. So that's the wait, and we don't know how long that wait that translates to. And this is a good question because it allows us to give some more information on this topic. We don't know how long that translates to because it's not necessary that every month the dates move. For many months or sometimes a year, the date doesn't move at all. So 2012 doesn't mean that you have 12 more years and then in 12 years you'll get it, because it doesn't move the date on a regular basis.
Okay. All right. So, Ashu, I hope this your question has been answered. Now, what we would like to do is we would like to move to another question. So, can we have another question, please? All right. So, this next question is from Michael Pereira. I hope I'm taking your name right. So, let's call you Michael. So, Michael wants to know, I have H1B and my green card is in process. Perm yet to be filed. I want my wife to apply for H4B first. Will she retain that status until I get green card?
Yes, absolutely. You don't even after you get a green. Even after you file for a 485, she can continue to be on a H4 if you continue to be on a H1, right? So your status only changes once the green card gets approved. And once your green card gets approved, then obviously she's going to be on a green card also if you file for her. You should. Because at that point, her H4 she'll fall out of status unless you file for a green card for her along with you. Then everybody will adjust together and get a green card together. But yeah, absolutely. Right now, you haven't even filed the perm. So you don't have to wait for your wife to apply for a H4. You can go ahead and file the perm. And then subsequently, your wife can apply for the H4. So one thing is not related to the other.
Okay, well, I hope this makes Michael, this makes yours and your wife happy. This answer makes yours and your wife happy. So now, thank you so much, Michael, for your question. Now, can we please move ahead and take our next question? All right. So the next question that we have is from Alpha Jen. Okay, Alpha Jen says, on L1B visa valid till 2025, facing a 5-year term limit issue, employer can't transfer to L1A, uncertain about H1B conversion, seeking advice for options to work beyond the 5-year term. What would you like to say?
I wish you would have asked me this 5 years ago instead of asking me after your 5 years are getting over, because then it becomes very limited. Your solutions to your question are very limited. But you can obviously file for a change of status. But if your employer can't transfer you to an L1A, even if you file for a change of status to a H1, the time on your L1 is counted towards your H1. So what you need to do immediately, if you have not done it already, is file the labor perm and get an I-140 approved so that you can then change to a H1 and you can file for a H1 beyond the 6 years, because you are in the 5th year right now, it looks like. So your clock is already ticking. So then file for a H1 beyond your 6-year period, because the time on the L1 is counted to the H1 as well. So you might have a year left on the H1. But if you have an I-140 approved, then you get an unlimited period of time on your H1. And that's what you should seek to be doing. So immediately you need to file for a perm.
Okay. Great. Thank you so much for your answer, Attorney Prashanthi. Now, I would like to tell our audiences and our viewers who are watching us right now that our system is not pulling all LinkedIn comments. So please log on to YouTube at Immigration Talk Show. So there, if you have any question, you can send in your questions. We will ask them from Attorney Prashanthi. So I would like to again tell you that our system is not pulling all LinkedIn comments. So please log on to YouTube at Immigration Talk Show. All right. So now, can we also have another question, please? Okay. So it seems a lot of questions are being asked today. So this question is from YouTube, and the question is from Harsh Haven. So Harsh wants to know, can I transfer my EB2 PD to an EB1 petition when changing employers to receive an L1A visa? Will my EB1 PD be current according to the visa bulletin, and how long does it take to get a GC EAD from filing?
Yes, so you can put your priority date. If you have an old priority date from an EB2 I-140, which was approved previously, you can definitely port that to the EB1. And if that makes it current, then you can immediately file for EB1 I-140 and 485. If it's current, then you can file the 485 concurrently with the I-140. And remember, it has to remain current until they complete processing it. If it retrogresses while the case is being processed, then you will be on a 485, but you'll continue to remain on a 485. You'll not get the actual green card. But presuming it stays current, the processing time for a 485 is about a year for employment-based cases. So if everything goes well, you should get your green card in a year if it is current. Your EAD usually takes a few months. It can take 3 to 6 months to get the EAD. So yes, I hope that was helpful.
All right. Thank you so much, Attorney Prashanthi, for your answer. I hope this answers your question. Harsh, now, Attorney Prashanthi, so, Alpha Jen, he asked a question, and he actually also have a follow-up question. I'm sorry, I missed it somehow. So what he wants to know is, what about F1 visa change of status? If you can please answer this.
What was his previous question? He's on a H1, right?
Yeah.
So he wants to file an F1 change of status?
Yeah, this on L1B visa valid till 2025, facing a 5-year term limit. This one.
Okay, got it. Okay, thanks for flashing the question again, because my memory is very short. So anyway, so he can, yes, in order to maintain his status, he can, of course, change statuses to an F1 or change statuses to a B2 even. But that change of status is temporary, right? So that is only for the purposes of then filing labor and an I-140. But yeah, immediately you can change to an F1 and you can look at moving to a CPT, but at some point you have to file the perm. For how long are you going to remain on an F1? And then again, when you change from an F1 to a H1, you still have the same issue, because you've used up 5 years and you don't have a green card labor pending or applied. So you won't be able to move to a H1 at any point of time. So while these other things are temporary, changing of status to a B2 or an L1 or an F1 or a H1 for the remaining period of time, you need to file a green card.
Okay. All right. So, Alpha, I hope your question has been answered. And see, we have taken your question 2 times. So, you have to be a consistent viewer now. And you have to call Attorney Prashanthi for, your matter, immigration matters. Now, coming to another question. Okay, so the next question is from Banu, and Banu wants to know, can I have unlimited H1B renewals with a new employer who won't pursue my green card, even though I have an I-140 approved for an EB3 GC with my current employer, and the priority date is distant?
Yes, you can file unlimited H1B renewals with your second employer, even though they may not be pursuing your green card. But if you want to get a green card, then you need to file a green card as well. I mean, the labor and I-140 as well with the new employer.
Okay. All right. Okay, that was short and to the point. So now, thank you so much for your answer, Tani Prashanthi. Now, can we also have another question? Okay, so again, we have question from Seema Singh, and Seema wants to know, F1 student here. I got my I-140 approved and receipts for my I-485 and EAD and advanced payroll. Should I stop maintain my F1 status?
Yes, that would be a good idea, Seema, because there is inherent conflict there. Because when you're on an F1, you cannot have an intent to immigrate. So if you were to travel on an F1, you're going to be in big trouble. They won't let you back in. So I think you should now move to a 485 status. Use your EAD to work as well as study. I'm presuming that you are also going to work because that's the basis of your green card, and so you should be maintaining your 485 status as well by working for the employer that's filed your I-140 and 485. So yes, you should stop being on F1 and change to a 485, especially if your I-140 is approved, and especially if you don't have any serious issues with your 485 getting approved, such as some kind of a having committed a crime, or if you've been unlawful in this country before, then you should worry about that. But otherwise, I would not worry about the 485 getting approved. So it's safe to
Okay.
change status, and just keep your 485 status.
Okay. All right. So, Seema, I hope you've got an answer to your question. Now, I would like to move to another question. So, can we have our next question, please? All right. So next question is from Elif Peter. I hope I'm taking your name right. I'm sorry if I'm not. So Elif Peter wants to know, after a brief marriage to a US citizen on an F1 visa, my husband faced deportation due to a withdrawn GC application. Now, with a Canadian passport, can he easily re-enter to the US?
So if he's been removed from the country for some reason, he will most probably be barred from coming into the US for 10 years or sometimes even for a lifetime. So that really depends on, what were the terms and conditions of during the removal proceedings, if there was a bar imposed. So it doesn't really matter what passport you have, that bar is applicable for everyone. So if you're removed from the country, coming back is definitely an issue.
Oh, okay. So, do we have any possibility of like re-entering if the person has been removed?
That
Not at all.
there is a possibility you would be able to maybe file a waiver. I don't know if his present spouse is a US citizen or not, but based on that, it's possible that that person can file a green card for her. So we need to get more information on this,
Okay.
on the facts to go more in depth. But is it possible? Yes, it's possible. Will you have trouble coming into the country? Yes, you'll have trouble coming into the country. So, to the extent of
Okay.
the question, that's how much we can answer based on the
All
facts.
right. Okay. Okay, so thank you so much, Attorney Prashanthi, for your answer. Now, next question. Okay, before we jump on to the next question, guys, should you require assistance with your immigration case, kindly contact law offices of Prashanthi Reddy via email at prashanthi@reddyesq.com, or you can also give her a call at 212-354-1010. I repeat the number, 212-354-1010, or you could also visit the website, which is mentioned here. Well, and apart from that, I also would like to tell you that if you're looking for a project placement or visa sponsorship, you can reach out to me on my email, which is rajni@higheritpeople.com, Rajni with a RAJNI. Yes, or you could also visit our website, which is www.higheritpeople.com. And guys, remember that we also sponsor H1B visas and green cards. Now, after that, can we have another question, please? Okay, so the next question is from boss Johnny. So Johnny says, I'm currently on my L1B visa. Can I apply for a green card through my employer using my L1B? Or should I go through the H1B lottery, get H1B stamped, and then apply for a green card?
I think we answered this question earlier. I don't know if it's a different person or it's the same question, but we answered it, and I said that there's no need to change to a H1 to apply for a green card. If you want to, yes, there are benefits of doing it, but by law you can still remain on an L1 and then apply for a green card based on the L1 also. But I guess the disadvantage of doing that is the L1B limit is 7 years. So if you 5 years actually for an L1B. So if you go past that, and you may not expect to get, if you're an Indian national, get your green card within that period of time. So in order to circumvent the term limit on the L1, it might be better to move to a H1 at some point, so that once your I-140 is approved, you can get an unlimited period of time on your H1, which that particular benefit is not there for an L1 because it's strictly just 5 years.
Okay. All right. So yeah, I think we also had this a question similar to this question from another user. But Johnny, I hope your question has been answered. So thank you so much for your question. Now, because the holiday season is going on, and wishing you all a happy holidays. And also, I would like to tell you people that I have a lot of holiday gifts. So we are also making, we at Immigration and Jobs Talk Show, we are also making this holiday season happy for you, and you should also feel like it's a holiday season going on with Immigration and Jobs Talk Show as well. So I have a lot of holiday gifts, like I was saying, like wireless chargers, backpacks, power banks. So you can please email me at rajni at hireitpeople.com, RAJNI at hireitpeople.com, and I will mail them to you, as Christmas presents or holiday presents. So guys, well, if you want.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@hireitpeople.com or visit our website www.hireitpeople.com.
Welcome back. You're watching me on Immigration and Jobs Talk Show. I'm your host, Rajni Bharara. And people, I would like to tell you that some technical issue is going on with our attorney, Prashanthi Reddy. I am sure she is trying to sort it out, but because, we are at the end of our show. So what we are going to do is, we have many questions from you. So what we are going to do is, we will try to reply to those questions on the platform that you have asked those questions on. So because of the technical issues, we will have to end the show right away. But don't you worry, we have another show coming up on Friday. So you guys stay tuned, and don't forget to subscribe to our channel. Yes, subscribe to our YouTube channel to receive instant alerts on shows and immigration updates. And like I've announced already, we have a show coming up on Friday. So you can, ask your questions there. But for now, I would like to thank Attorney Prashanthi for coming to the show and taking time out and doing the show. And thank you so much for joining in and watching the show. So before I go, happy holidays and stay tuned. Keep on watching, and I'll see you next week. Bye for now.